Thank you, everybody. My name is Ian Watts. I'm the practice leader for Marsh, UK and Ireland. We're delighted to welcome you this morning, and we're very pleased to be providing this webcast in collaboration with COFAS, with Norton Rose Fulbright, and with Moore Kingston Smith. Now, these insolvency reforms have been under discussion for a number of years. That the pandemic created further urgency in order to push these reforms through and create an environment that gave businesses a better chance of working their way through financial difficulties rather than being forced into insolvency. We've got a very experienced panel which will give a lawyer's view, an insurer's view, and a broker's view. And the speakers will be joined on the panel by an insolvency practitioner and Sarah Derrick, who's the risk underwriter in the COFAS global team. We've got a few questions in already, and please do use the Q&A button to ask any additional questions that may arise during the session, and we'll address as many as we possibly can at the end. This, the slides will be shared with you afterwards, as will the recording of the session. So no need to take notes. You'll get everything that we're sharing with you after the session. Before we get into the core, I just wanted to reflect on where we stand and what we're seeing. And I'll bring Frederick, who's the MD of COFAS UK and Ireland, shortly for his views on what he's seeing in the marketplace currently. So right now, we're well into the first recovery phase. And early signs are that there's a definite upturn in sentiment and productivity. The latest stats that we're seeing indicate that the situation is better than expected and the situation is improving globally. However, that is tempered with some caution because alongside the recovery, we're seeing also signs that the pandemic causes fluctuations and increases in the levels of infections around the world. And these flare-ups need to be controlled very quickly. However, generally the consensus from the organizations we talk to is that business is on track to start that recovery phase, but we all have to work on this together. And it's really important that we collaborate both with our insurers, with insolvency practitioners, with our fellow professionals to make sure that the recovery continues in the way that we want it to. But firstly, if I can just introduce Frederick and get Frederick's view on what COFAS is seeing, both within the UK and Europe, but also globally. And maybe asking the question is what's keeping Frederick awake at night, given what they're seeing. Frederick, can you pick up on that?
Yes, thank you, Ian. Good morning, everyone. Indeed, the situation is probably not as dire as what you would expect given the macroeconomic outlook and the fact that depending on the point in time, the Bank of England has stated that the UK economy would shrink by 14%. A few weeks later, they said, no, it might not be 14, it may be 8%. And then the economy starts converging towards maybe 10, 11% drop in GDP. What we are seeing, or what we have seen since the middle of March, is a steady rise in claims notifications. But what is interesting is that although there is a big rise in numbers, the values are still more or less under control. Of course, the aggregate values are up because of the number of claims, but there have been very few, barring exceptions, very few big losses. So there is another element which is interesting, is that although the number of claims has gone up very, very steadily, the nature of these claims has been different to what we had experienced previously. So currently, well over 90%, and I would say probably over 95% of the claims we have received in the UK are protracted defaults against insolvency. So it's less than 10% and probably less than 5%, which are straight insolvencies. The same picture is also true to some extent in other European countries and more generally around the globe. So what this means is two things. The first one is we need to have the most accurate information on the most up-to-date information in order to do our business, be it on the underwriting side or in terms of collections. And it's sometimes very difficult because although, yes, the economy is reopening, when we are contacting some companies because we want to support our clients, sometimes the companies are not yet in a position to respond to our request for up-to-date information. And the second thing is exactly what this session is about. If the overwhelming majority of the claims notifications we receive are linked to protracted default, or the inability to pay now, or the unwillingness to pay now, because there is also that, which we have noticed. Then how do we act? How do we make sure that our clients get their money back? How do we make sure that the whole industry works more or less normally? So that's the big question, and obviously our panelists will be able to provide some answers as to how we act and we interact in these circumstances, taking into account the latest measures and the latest official developments. Now, Ian, you're asking me what keeps me awake at night. Clearly, in the context of this lack of information, it's having a big claim from a company which normally would be more or less solvent, but since our information is very aged, we cannot see exactly how it is trading or how it has been trading for a number of months, and suddenly we start having very big claims, and the picture changes materially from one day to the next. So far, we've been lucky; we've not had that. But when you look at the recent announcements by a number of large corporates, most of which have drawn their RCFs, so basically they have drawn their facilities to pump up their cash levels. At the same time, they are starting to give guidance at how much their cash flows are under pressure. And that's where you're seeing that a lot of them are flush with liquidity, but that liquidity is going fast. And so this is what keeps us really awake at night, is making sure we can understand that play between an initial position which is strong and a trend which, if the economy does not recover fast enough, or if there is a second wave, might put into jeopardy some of these bigger companies. So that's really where we are. But again, as of now, the big question mark is, with so many protracted defaults around and a steady rise in non-payments for various reasons, how do we collect the money? Okay. With this, over to you, Ian.
Thanks, Frederic. Appreciate that insight. And just again, a quick reference point. This session is in collaboration with COFAS and also Norton Rose Fulbright and Moore Kingston. So there are views from other insurers, which Eddie will cover off a little bit in his session towards the end of the webcast. What I'd like to do now is introduce Alison Goldthorpe. Alison Goldthorpe is a lawyer at Norton Rose Fulbright. She'll give her perspective, what she's seeing, and hopefully you find it interesting. Alison, if I can hand over to you.
Thanks very much, Ian, and thank you for asking me to speak on this panel. I'm a partner in the financial restructuring and insolvency team at Norton Rose Fulbright, and I've been looking at the new provisions of the new Act over the last few weeks. And I think it's fair to say this is the biggest change we've had in insolvency and restructuring law for over 20 years. So we're facing big changes that we all need to get on top of very quickly, both in terms of understanding the law, but also probably more importantly, the practical effect of all these measures and what they mean for our clients and how they fit together. So on the next slide, I set out what the Act does. And one of the difficulties with it is it does a lot of different things, and it's quite hard to grasp on first reading. So I'll just try and summarize it for you on this slide. There are a number of permanent measures. There are temporary measures, and I'm just going to summarize the initial effects on creditors. So the permanent measures are a new standalone director-led moratorium. So this is a big change for English law. This is the first time we've had a debtor in possession process with a moratorium where directors can lead the rescue, and the creditor's interests are protected by an insolvency practitioner who is the monitor who supervises what they do, and I'll come back to that in a minute. The second big change is a new restructuring plan, which is our version of the scheme of arrangement, which allows classes of creditors to be crammed down. But it's also more than that. It enables you to compromise with secured and unsecured creditors. So as suppliers, you may well be asked to vote on a restructuring plan in the near future, because the general feeling seems to be that this is going to be used for restructuring a lot of businesses in the coming months. And the first plan is already underway in relation to Virgin Atlantic, which is going out to the court and then to creditors in the next few weeks. So this is probably going to be the way that restructures are often undertaken going forward. The third big change, permanent change, is a prohibition on suppliers being able, unless they're exempted, to terminate contracts by reason of insolvency. And obviously for this audience, that's a key change, because it's going to widen the ability of the directors in a restructuring procedure or the insolvency practitioner to say to the supplier, we want you to continue to supply. So that's another big change, because hitherto, as a matter of English law, the position has always been you can decide the terms of your contract, you have freedom of contract, you can decide what's in your contract. This is a change, because it's saying you have to continue to supply in certain circumstances. So we've got a number of temporary measures as well, relaxation of wrongful trading provisions, which was widely trailed in the press. And importantly, again, for suppliers, the prohibition on presenting winding up petitions. Now, initially, those changes were going to the 30th of June. They've now gone to the 30th of September. And I would say that's probably why we're not seeing a lot of insolvencies at the moment, because it's very difficult, if not impossible, really, for suppliers or landlords to get winding up orders made against non-payment of debt to them, because of this ban effectively on presentation of petitions. And I think that'll be mentioned later on in the presentation. You're only allowed to present a petition if you, as the petitioning creditor, can say the company has not suffered a financial impact as a result of coronavirus, and that's pretty difficult with most companies to do that. There's also an extension of time in the Act for filing of accounts. So if you're looking for details of the financial position of the person you're supplying to, it's difficult to get up-to-date accounts, because those have all been extended by the government. In summary, this is a really rescue-led piece of legislation. It's very debtor-friendly, very different to what we've had in the UK before, where we've been usually creditor-friendly. And the whole message of it is rescue, rescue, rescue. This is the government's answer in legislation to the support for businesses it's given by the JRS, the tax deferrals, and the other measures introduced cash-wise by Rishi Sunak. So on to the next slide. I just touched on this very briefly. I just want to remind you that there are also two other changes you need to bear in mind when looking at your position as a supplier. At the bottom of the slide, the increase of the prescribed part, that came in earlier in the year in April. That's 600,000 gone up to 800,000, and that's the pot that's left for unsecured creditors from floating charge realisations. But if you're dependent on floating charge realisations, that's another deduction. And then second bullet at the bottom, reintroduction of Crown preference. That was trailed in the Finance Act in the budget, and is likely to come back in December 2020. I'm involved with R3, the trade association for those involved in restructuring. We're lobbying hard to have that deferred, because we think that really doesn't help in the current situation. At the moment, though, it's still probably coming back in December, and it also dilutes floating charge realisations. Final point on that slide, the Act gives a lot of power to the Secretary of State to make amendments to the Act if it doesn't work. This has come in 6 weeks. Again, unheard of in English law to introduce such a complex piece of legislation so quickly. So I think it's accepted that bits of it won't work, and there are powers for the government to tweak it. And that's likely to happen. So it's watch this space. We may have to do another of these sessions if things change fundamentally. So on to the next slide, the moratorium, what is it? It's a new director-led process. It's our version of Chapter 11, but importantly, Chapter 11 in the US leaves the directors in control under the supervision of the court to try to rescue the business. We have the directors now in charge of the company to seek to achieve a rescue, but under the supervision of an insolvency practitioner who acts as the monitor. And the whole purpose of this is rescue. It is not to sell the business, so it is to rescue the company as a going concern. It's not a sale of the business and assets. And the monitor is representing the creditors who are standing still, and he has to make sure the directors are on track with the rescue and that they're making the payments they have to make in the period. So on to the next slide, it's not available to all companies. If you're looking at your customer, you need to look at whether or not they're eligible or not. So there's a whole list of exceptions which you can look up in the schedules to the Act. Largely they're banks, insurance companies, but also parties with capital markets arrangements. So that is bonds. If they've got bonds of at least £10 million, they won't be eligible. Next slide, how long is the moratorium period? Initially 20 business days, but then it can be continued for another 20 business days without any creditor consultation, provided that the monitor is happy that the rescue is on track and that the payments that have to be made are being paid. So that's effectively, I think in most cases, if it's on track, 40 business days. Then after that time, there needs to be consultation on any extension with the creditors, who vote by majority in value on any extension, or by application to the court. And again, in both of those considerations, the focus will be on, is the rescue on track? And that's the rescue of the company, not a sale of the business as a going concern, the rescue of the company. And the court will only make an extension if it considers that that's key. So the sort of likely scenarios when you use this is where perhaps at the moment you're a restaurant chain, you're trying to open up after lockdown, but you've got difficulties with social distancing. You can't open all your restaurants at the moment. You've just got no idea what your cash flow is going to look like because people aren't really going out for a meal. So you aren't really in a position to propose a CVA at the moment. And therefore, you need more time to actually have some proper cash flows before you propose the CVA and you understand what your business looks like by January next year. You're facing creditor pressure from a landlord, say. So this example has to move forward to October when the landlord can petition. The landlord's threatening to petition on the closed stores. So you go into a moratorium to try to formulate the CVA proposal. You then have some cash flows to base the CVA proposal on by January. You make that proposal, you come out of the moratorium, go into the CVA. That's the idea of it. It gives you a staging post to get out of the financial difficulties into a rescue of the company. So that could be a new plan, a CVA, or a refinancing. It isn't a sale of the business. So on the next slide, how's it terminated? Well, the monitor, as I've said, he's watching the position of the creditors standing still. He has to terminate on one of four grounds if he sees those things happening. Firstly, if he thinks that there's no longer a likelihood of a rescue, so he's got to be sure that the rescue is on track. Two is the best case scenario, that the objectives achieved and the rescues happen. 3, he can't monitor because the directors aren't giving him the information. Or 4, the company isn't making the payment. So a good check and balance on the directors in terms of looking at what they're doing, but without the costs of court applications as you have in the US. The other way that it can end is if the period expires, or if there is a compromise, a CVA or a new plan, or sadly, if the company goes into a subsequent insolvency process. So on the next slide, importantly, what has to be paid? In the moratorium, you have to pay 2 types of debt. Moratorium debts, which are debts that you incur in the period, and pre-moratorium debts for which there is no payment holiday for amounts falling due during the moratorium. It's a bit of a wordy definition, but what it means is that there are certain categories of debt that are not frozen during the moratorium period and which have to be paid. The starting point is that to understand this is that all debts at the time of the moratorium are frozen. There is a payment holiday for all of those debts in the pre-moratorium period. Then going forward from the moratorium, you have to pay the categories I've set out on a slide in A to F. The monitor's remuneration, goods or services supplied during the moratorium, which is an important one for this audience. C, rent. D, wages or salary. E, redundancy. And F, importantly, debts or other liabilities arising under contract or other instrument for financial services. So banks and other lenders will get paid interest in the period. And if amounts fall due to banks in the period, then they also get paid. There was a lot of debate on that in the period between the bill becoming law. And it's clear from what's come into force that actually banks can accelerate debt during the period. They retain their contractual rights. But if they do that, they're effectively going to scupper the moratorium because the company won't be able to pay and the moratorium will fail. So effectively, you're going to have a standstill really with your lenders before going into this process. Otherwise, the rescue isn't going to work. Moving on to the next slide, what does this prevent creditors doing? You can't enforce your debts. You can't have a right of forfeiture. No enforcement of security other than collateral security charges, which are share charges. Usually at the top of a group of companies, there may be a share charge. That could be enforced, and then the businesses could be transferred to a new holding company, and that could be the restructuring, but the businesses underneath remain intact. Other than that, no enforcement by lenders. So no appointment of administrator by lender. That's the key issue. No repossession of goods, and no legal proceedings to be taken, continued or executed against companies. And you can go to the court to try to get these waived, but not in respect of pre-moratorium debts. So pretty much a standstill from the point of view of unpaid debts to suppliers. So moving on to the next slide. What about super priority? There's a lot of talk about super priority. During the moratorium period, it's business as usual for the lenders. And as I've said, they're allowed to accelerate. but the accelerated debt will not be super priority in a subsequent insolvency. So what is super priority? The principle is that if you advance credit during the moratorium period, you should be paid, and if you're not paid, you're then super priority in the subsequent insolvency if the moratorium fails and the rescue fails. So if I'm a supplier, I supply goods in the moratorium, I'm not paid for whatever reason, I'm then super priority in the subsequent administration, and that means I'm paid before the fees and expenses of the subsequent administrator. So that's very top slice, and that's out of floating charge realizations. Fixed charge realizations, as normal, would go straight to the fixed charge holder after the cost of realizing the security, but floating charge is an extra limb at the top of that waterfall that means that the people who've extended credit in the moratorium period are paid. But importantly, lenders are not allowed to claim accelerated debt in that super priority because it was agreed that that was unfair. So that was amended in the House of Lords. So the key thing will be to understand, if you're involved in a subsequent insolvency, what the super priority debts are from the moratorium, so you understand what the waterfall will be and what will be left further down in terms of payments out of the floating charge. So that's a big change. We haven't had anything like that before. Quickly moving on to ipso facto. This is a, next slide please, this is a restriction on suppliers using clauses in contracts which allow termination for reason of insolvency. We used to have this just for limited essential supplies, electricity, gas, telecoms and IT. Now it's to cover all supply agreements, a supply of goods and services, no definition of that, so no doubt some litigation on that, but all those suppliers are prohibited from terminating by reason of the insolvency, and that's administration, liquidation, administrative receivership, or the two new procedures, moratorium or the plan, and unless you're excluded. So certain categories of supplier and categories of contracts are excluded. On the next slide, I set out those, the categories of suppliers, insurers, banks, etc. Supply contracts, again, largely financial service related. Moving on to the next slide, what you actually can't do, you can't terminate for an insolvency event. So you can't say, I'm not supplying because of you going into the moratorium. And you can terminate for another reason in the moratorium. So if the person doesn't pay you in the moratorium, you can then terminate, but you can't rely on an earlier right of termination that you didn't use. So you're probably going to need to look at termination rights as they arise to make sure you decide whether or not to use them at the time, because you may not be able to use them later on. You cannot withhold supply on the basis that you haven't been paid arrears. Those arrears are standing still in the moratorium and in the administration, and the continued supply is on the basis that your supplier is paid for the payments in the insolvency process, but isn't able to demand that you pay the arrears as a condition of ongoing supply. So in short, we think there'll be a lot of discussion between the directors or insolvency practitioner and the supplier, and the key thing will be communication, because they won't necessarily want all supplies to be continued. So I think the first thing to do practically is to contact the insolvency practitioner or the directors who've gone into the moratorium and confirm actually what they are intending to do in terms of ongoing trading and supply, and discuss the arrangements for that and the arrangements for payment. So finally, how will it affect suppliers and lenders? I think lenders are accepted, so they can't be forced to continue to lend, and their rights continue. Lessors under operational leases, in contrast, will be forced to continue supply, but they will be paid for ongoing supplies. So communication, as I've said, is the key. Look to contact the person going into the insolvency, and suppliers are likely to look for earlier triggers for termination in contracts going forward, and think about exercising termination rights early if there are grounds for doing that. Very finally, because I'm over my time, I just want to mention the restructuring plan. You can look at the slides later, but you may be asked to vote on a restructuring plan. It's like a CVA, but a bit different. And again, I think you'll need to take advice on the effect of that plan for you. But those are going to start coming in front of you on your desk for consideration. So it's worth having a look at these slides afterwards as to what's involved. Thank you.
Alison, thank you. That was absolutely terrific. It's 500 years of law, British law or UK law in the space of less than 15 minutes. It's an incredible feat. And you will be pleased to know, I've already mentioned this, that we will share the slides with you afterwards. So whirlwind whiz through the new insolvency framework. Thank you very much for that. I'm now going to hand over to Hans Meyer. Hans is Director of EICC at COFAS, and Hans is going to walk through the insurer's perspective. But as I say, this is COFAS's perspective, not necessarily all insurers' perspective. So Hans, thank you very much.
Thank you, Ian, and thank you also for the invite. And like you said, I wanted to look at this from a viewpoint from COFAS. A couple of topics I wanted to look at, which was the winding up petition and also wrongful trading. How does that impact on COFAS, and how do we take those into consideration for our risk assessment? Also looking at changes to the company filings and meeting requirements with Companies House, and finally, which is going to be the hot topic, is the new moratorium. On the wrongful trading side, we've got the obligation for a director to continue to supply, to continue to trade, but also that he should not be doing so if he is trading financially insolvent. The law has allowed him to continue to trade. And where do we stand from a COFAS's point of view? From my perspective and from COFAS's perspective, in the circumstances and irrespective of whether the law on wrongful trading has been suspended, board of directors should constantly keep the question as the company's future viability under consideration. We appreciate it's extremely difficult given the uncertainty of every business that is facing, but it highlights the need for regular board meetings, the need carefully to minute decisions throughout this process. Our position, however, is unchanged, and all claims will be dealt with accordingly. On the late filing, this is interesting. From the late filing, it now allows for a business to have a 3-month extension for filing their accounts. Worthwhile considering here that this filing predominantly relates to 2018 and 2019 accounts. So these are financials that do not reflect the coronavirus impact on that business. This is more the ability to finalize previous set of accounts and to have them entered into Companies House. Not delaying these accounts, it's unclear at present whether Company House will make this even evident on the records, but not filing these accounts will not allow us and will not give us the ability to assess the risk. So not filing can be viewed as negative, but at the moment, again, this will be viewed at an individual basis. Most insightful data to assess the risk is current financial statements. So we will always be looking for current statements. And at the moment, we are actually going around some of our clients and their suppliers looking at questionnaires on how the coronavirus has impacted their business and how we can assist them in their ratings. Under the moratorium, the legal protection, the aim of the act is to limit the number of companies entering into insolvency. This is intended to give the companies breathing room to look at a restructuring option with the intention of saving the business. As Alison has mentioned, it's a director-led process, and one of the key provisions is an extendable 20 working day, giving business protection from creditor actions whilst they seek professional restructuring. We do treat the moratorium as an adverse event, so policyholders are expected to notify just as they would in any other adverse event. We do not treat this as an insolvency event, just as an adverse event. The directors must notify the monitor, who must send a notice to all known creditors and the registrar of Companies House. Therefore, it will be a matter of public record that a company has entered into a moratorium process. However, at this time, there are no plans to add them in Companies House for the bulk uploads on which we rely within COFAS. So we rely very much on the policyholders to make us aware of this. All future suppliers must also be advised that the business has entered into a moratorium. Again, it's down to the policyholders to notify COFAS. Under the continuing supply, and this is an interesting part, the Act removes the supplier's right to invoke any termination of contract provisions, as Alison's mentioned. The crucial part from a COFAS stand is that there are no arrears at current outstanding pre-moratorium, but we will consider this on a case-by-case basis. The position in this scenario, for example, is a waiver of the allocation of funds received on uninsured trading against the holders' debt. So for us, we need to look at that and where does the monies that are being paid, which usually are allocated against the holders' debt and now are made potentially payable against the current debt, how are they allocated? If the eventual failure of the buyer is expected and would cause the policyholder financial distress, then he can request the courts to terminate his commitment. but we would recommend that all our clients seek, review their sales contract and seek independent legal advice so they fully understand their obligations. And finally, there has been a lot of changes, not just in the UK, but also in the EU as a result of coronavirus. And from March onwards, in anticipation of the consequences on corporate liquidity caused by containment measures, the government of the main European economies have temporarily adjusted their legal frameworks. Germany, Spain, France, Italy. The only exception is the Netherlands at the moment, who has not implemented any emergency insolvency measures since the beginning of the pandemic. We've got this available to everybody on our website. It's a read by Bruno de Moura Fernandez, who's our Western European economist, and he's got a publication out there talking about these. It's an interesting article, also looking at all the impact of the coronavirus and what the governments have done on the European front. With that, I hand it over to Ian and Eddie.
Thanks, Hans. Thank you very much for that. And just please do keep the questions coming in. We've got a few questions from the original registration. We're getting a few questions coming in. And if there are specific questions that you have that you think of after the session, then I'm sure we'll be very happy to take care of those as well. So what I'm going to do now is pass over to my colleague, Eddie Feather. Eddie Feather runs the claims team for the trade credit business. As the guys have mentioned already, that the levels of insolvency that we're seeing are probably in a bit of a vacuum right now. So there's not that much coming through. We do expect that to change as some of the repayment plans and reschedulings and deferments of payments come through towards July, August, September. But Eddie's going to give the broker's perspective on what the reforms mean for trade credit insurance. And then we can move into the Q&A session after that. Thanks, Eddie. Over to you.
Thanks, Ian. Good morning, everyone. I just plan to speak a little bit about some of the credit insurance policy implications. So what do you do when something goes into a moratorium? Well, all insolvency events should be reported immediately to your insurer. And this is no different. And all insurers will treat a moratorium as an adverse notifiable event. And this should be reported in your usual way immediately to your insurer. We would also recommend you advise your broker. So what can you do when something enters a moratorium? Well, you've already had it explained that there are prohibitions, so on winding up orders and enforcement of any security, such as ROT. However, there are always policy obligations to mitigate loss. And so for those companies who are credit insured, we recommend at this time that you seek the advice of your credit insurer via your broker. For those who are uninsured, we recommend you either take legal advice, or if you use a collections company, consult with the collections company you use. It is our expectation that what insurers expect to be done will become clearer as we all become more familiar with the process. Is an insolvency event, is a moratorium an insolvency event under your policy? At this time, there appears to be no consensus as to how all credit insurers will treat this. We've heard a little bit from COFAS today, haven't we, that they're going to treat it as an adverse event. So different insurers are expressing different views depending upon their policy wording, and we await formal clarity from each insurer. Some insurers are treating this as an insolvency event, which means you can make a claim under your policy. Others intend to treat this as an adverse event, which will become claimable when default occurs. So far, only Atradius and Tokyo Marine have formally confirmed their positions, although we've heard from COFAS today. Atradius will generally treat a moratorium as an insolvency event, whilst Tokyo Marine will not. We also believe EULA will align with the Atradius position, and and COFAS have confirmed their position today, haven't they? So it all comes down to the application of each insurer's policy wording. We also understand some insurers may also introduce a new policy wordings to deal with moratoriums, but we will of course advise more when the insurers confirm their positions. Next slide, please. Right. Do you have to continue to supply? Well, we've had explanations, haven't we, about this already. So the requirement to continue to supply depends upon whether or not you had a contract to supply the company prior to it entering a moratorium. The legislation suggests that if you have such a contract, then you could have to supply, and you will be unable to change the terms. So you'll be prohibited from, say, making pricing changes. There are also a couple of exceptions to this rule, such as the small company exception and also the hardship exception. However, as yet, hardship has not been defined and must be approved by the court. This could be a high bar to get over, but we don't know yet. It is expected that hardship will likely be defined as an expectation to show that supplying is likely to result in the supplier being forced out of business. On the other hand, if you do not have a contract but receive new requests and orders, then you will not be obliged to supply. So will credit insurers provide any cover on a company in moratorium? Well, that's extremely unlikely. We expect all credit insurers to either remove cover when a company enters a moratorium if a credit limit is cancelable, or where the credit limit was underwritten on a non-cancelable basis, the adverse event will trigger the application of a stop shipment clause. As a consequence, any future supplies of goods or services to a company in a moratorium or in an insolvency procedure, we expect to be uninsured. Following on from this is the question of how insurers will treat the money received for supplies during a moratorium for their insured customers. And COFAS have again commented on this a bit earlier. But I'm speaking from the perspective, say, of all insurers. This is extremely important to understand. Most insurers have an allocations of money clause or a recovery clause. This means that the money received for supplies or services provided to a company in a moratorium, or any insolvency procedure for that matter, is typically allocated by insurers to the oldest debt in a chronological order. This in effect reduces the older insured debt as opposed to paying for the new supplies. Now, you're probably thinking there is a potential conflict here, where on the one hand you have to supply, but on the other, this impacts on the potential value of a claim against your credit insurer. At this time, insurers are only advising us that where an insurer intends to or has to supply a company in a moratorium, then an insured must seek an allocations of money or a recoveries waiver via their broker. This waiver, if granted, would allow money received in respect of new supplies to the moratorium to pay off those new supplies, whilst the older uninsured debt remains frozen. Insurers will consider this on a case-by-case basis, but they have not at this time said they will automatically grant salvage waivers. I think insurers will want to satisfy themselves that there is no alternative but to supply, and that this is the best course of action to mitigate their and your potential loss under the policy. So we've heard about super priority, and what does this mean, and will you get paid? Let's take a step back for a second and remind ourselves that the purpose of the moratorium is to find a way for the company to continue to trade as a going concern. Debts owed prior to a company entering a moratorium are frozen unless they fall into the exceptions list. If a moratorium fails, and if as a result any subsequent formal insolvency proceedings are initiated within 12 weeks of the failure of the moratorium, some creditors, those who supplied during the moratorium, and some pre-moratorium debts would take priority and should be paid ahead of the floating charge holders, but not before the fixed charge holders. This is subject to there being sufficient funds in the insolvent business's estate. In theory, any debts incurred by a company during a moratorium or other insolvency process take priority and should be paid for. So as we've said, new supply should be paid for, but there still remains the possibility, albeit we believe small, that a company which enters a moratorium could enter another insolvency process, potentially leaving debts unpaid that were incurred during the moratorium. However, to repeat, as we understand it, for those debts incurred during the moratorium, there is an expectation that payment of the super priority debts is very likely. So what happens if you're asked to vote on a reconstruction or scheme of arrangement? Well, from the insured's point of view, if the debtor company puts forward a reconstruction or scheme proposal, then yes, insurers will expect to be consulted. They will want to discuss what they believe is the most sensible course of action. Next slide, please. So much of this is untried and untested. and is brand new legislation. So we do have to wait to see. So inevitably, there are questions we don't know the answers to at present. For example, how will insurers treat a scheme of arrangement or compromise agreement? Well, we've not specifically received advice at this time on this as to how all insurers will approach this, but most have language in their policies that they will treat such an arrangement as an insolvency event. And this is what we expect from all insurers. Another question might be, how will suppliers behave going forward? Well, clearly at this time, we'll have to wait and see, but there could be an impact on how suppliers behave or contract with their customers in the future. I think Alison alluded to this earlier as well. There is a potential issue for some suppliers who are credit insured and operate with franchises or distribution agreements. These agreements typically have termination clauses. As a result of the new legislation, it may be that some franchisors or manufacturers will want to be a lot quicker to terminate these agreements before the chance of a franchisee or distributor entering a moratorium. As I've said, we don't know the answer to how suppliers will behave. However, as regards your credit insurance policies, we would just remind insureds that should they wish to terminate a distribution or franchise agreement with their customer, this is regarded as a material event, and insurers expect to be consulted before the insured acts. Otherwise, the cover in the event of a claim could be put in jeopardy. In fact, some insurers have this as an express exclusion in their wordings. So will this be taken up going forward, or will it be rarely used? Well, Alison thinks it will become the way forward. We heard it a little bit earlier. But I was just speculating whether or not the new moratorium legislation might be a bit of a Y2K moment for those that can remember and not be taken up much, but others may have a view on a different view. Again, we will have to wait and see. Next slide, please. Right, before I hand back to Ian, I have just this final summary slide just to remind you of some of my key points. So as regards, if something enters a moratorium or any insolvency process, make sure you report to your insurer immediately. All policies have policy requirements to mitigate loss. So you need to consult with your insurer via your broker. Can you claim under a moratorium? Well, we've heard today one set of views, and we know there are different views from insurers, whether or not it's a claimable event. Again, you'll need to consult with the insurer via your broker. Until such time as all insurers make this clear. Do you supply a moratorium? Well, if you have to and you're insured, we absolutely recommend you seek a salvage waiver because of the way insurers allocate money to the oldest debt, and insurers will treat this on a case-by-case basis. Finally, if in doubt about anything, your broker's always there. Please contact him. And hopefully they'll be able to guide you through this process. Back to you, Ian.
Eddie, thanks for that fascinating insight into what we're going to be dealing with going forwards. We've got around about 15 minutes for Q&A session. I've got a number of questions coming through. I was going to chuck the first question towards Ian Roberts, who's head of recovery at Moore Kingston Smith. He's an insolvency practitioner. So Ian, are you up for the first question? This is what happens to a company if the moratorium is terminated due to a breach in the rescue package? Can the supplier take action?
Well, I mean, the whole problem when you've got a moratorium that's failed is it's going to end up in a future insolvency procedure. So if you've then supplied that company during the period of the moratorium, you will, as we've heard, have a super priority claim in the insolvency. For your old debt that existed at the time the company went into a moratorium, you will just have an unsecured claim like you always would if you were faced with an insolvency and you had arrears that were due to be paid. So I suppose nothing really changes other than you've got this super priority debt, which means that you've got a very good chance, I would say, of getting your money back should the rescue fail. Okay.
Hans, have you got a view on that as well? Is that you? Because in the pre-session that we had with these guys, there was a lot of debate, a lot of a bit of consensus, but not everybody agreed with each other. Hans, would you go on with Ian on that point?
I would, yes.
Good. Another question, if I can put this one to, again, to Hans or to Frederick. If I had a poor payment performance prior to the moratorium, i.e. consistently were behind the due dates, messing around with payments, is that not grounds for refusing to supply going forwards if they are in a moratorium? Do the suppliers have it or not?
If there is a pre-moratorium, or if there's any negative trading information prior to the moratorium, undoubtedly the credit insurance company will have already put restrictions on that particular buyer.
But if they're not credit, how would that work? So if there was no credit insurer in the background?
If there is no credit insurer in the background.
Yeah. So maybe that's a question for Ian or for Alison. So we've got a situation. Yeah, sorry.
Can I say, from an insolvency practitioner's point of view, and remember this relates to administrations as well as it relates to moratoriums, we can, as insolvency practitioners, force the supplier to supply, even if the company, and quite likely that company has always had bad history of payment, because that's what, they're in an insolvent position now. They probably haven't paid a lot of their creditors for some time. And we as administrators, or as I say, monitors of a moratorium, we will want our key suppliers to supply that company. I would say that, in a situation where the supplier really doesn't want to pay, it's going to be very difficult in practice to, one, force them to pay, because going to the court is going to be an expensive and probably quite long-winded process. And actually, if they are a key supplier and I've got to deal with them in terms of managing my administration or dealing with the directors in trading a company through a moratorium process, I want to have a good trusting relationship with that supplier. So actually, starting that relationship in court is probably not going to be the best solution. So I would, on a practical basis, probably want to find an alternative supplier if I can.
And I think it comes back to the point I was making, which was communication. So I think if someone like Ian is appointed as the supervisor, as the monitor, or he's an administrator, he's going to communicate with the suppliers and actually explain what the rescue is that he's trying to put forward and what supplies are needed for that, and whether it's possible to use other suppliers or not. And I think this is really going to only really bite on people that are essential to that company, in the sense that there isn't anyone else that supplies the particular widget that's needed to finish off the product or whatever it is. And in that case, then he really will push them to supply. But in most cases, he'll say, do you want to continue to supply, and I'll pay you on the normal terms. And there's another question that's come up on the chat that says, can I change the terms? No, you can't. You have to continue to supply on the terms that were originally in the contract. And if they're not prepared to, then Ian, as the monitor, supervisor or administrator, will look to see if there's someone else who would do that supply.
But in practice, Alison, and this goes for all insolvencies, doing insolvency as an insolvency practitioner, running an administration, we're going to be we have in the past for years and years been faced with having to address suppliers' concerns about supplying a company in administration and persuading them to supply. Now, we've still got to try and do that. We've got a bit more law on our side now to try and force the issue. But the last thing I want to do is force the issue. What I want to do is have a trusting relationship with that supplier and make sure that they actually believe me when I say to them, we will pay you. Yeah. We will work with you. They don't want to cut their nose to spite their face. It may be that they're a key supplier to the business, and they don't want to lose 10% of their own turnover by not supplying us.
And let's remember that the point of this is to try to achieve the rescue of the company. So the idea is that the supplier will have a customer going forward. That's the whole point of this change in the law. So exactly. It's trying to preserve the value in businesses where actually key contracts are part of the value, by getting those contracts to continue so that the company is then restructured and then continues to be a customer that pays. So the whole idea, it comes back to the point of the Act, which is rescue, and everybody working together to try to achieve that rescue. So it's not trying to get away with not paying, it's about paying during the period of the restructure, and then hopefully on the other side, there being a customer that does pay regularly in the future.
So hopefully the fact that we've got this law in the background will actually help with collaboration and negotiation. What I don't want to have a situation is that we always end up in a court of law, because that's not going to work.
No.
Ian, could I just comment? As I pointed out, though, one of the challenges here is the speed with which insurers will look at allocations of money waivers, because, you know, companies being forced to supply, and from their perspective, as a consequence of that, their insured debt might diminish versus the outstanding debt in a moratorium from an insurer perspective, could be a bit of a conflict there. So we are going to have to deal with this issue and find a way forward very quickly with insurers on terms of what we call allocations of money or salvage waivers. So the IP profession needs to be aware that this is going to be a key critical aspect to suppliers who are insured.
But even, you know, I remember 20 years ago talking to credit insurers because suppliers couldn't supply, even though they actually wanted to, because they would only supply with insurance. So, you know, yes, there's has to be a negotiation going forward. But, you know, the trouble is with insolvency practitioners, we need the supply today, we need it tomorrow. We can't hang around for a week or a fortnight. By then, the business is dead. So we need the whole market to adjust to be able to provide this key supply urgently.
Can we put that to Hans and Frederick? So that scenario whereby the supply, there's a very specific question that's come a couple of times, that this allocation of monies waiver needs to be reacted to very quickly. Have COFAS got any thoughts about how that would be handled going forwards?
We can take on this on a case-by-case basis. It is impossible to, at this point in time, to make a general wide-sweeping statement to say that we'll waive this. For me, this is not an insolvency. For me, this is the potential to get the business out of insolvency and to avoid insolvency.
Okay, so without putting words into your mouth, would you imagine then that you would be more open to allowing that waiver of monies to go forward more often than you would have done in the past? Is that?
Yes, we will.
What we're seeing is a timing issue, that these things need to be reacted to very quickly across all sectors of the economy.
We are currently in negotiations with certain of our policyholders in relation to continuing supply and supply to support their business. Like you said, we're talking about restaurants and pubs who are trying to re-establish themselves again, opening up their doors. But what do we do with their pre-business debt? So this is done on an individual client basis, and we look at their and we assess their needs.
Okay. So a couple of other questions, maybe one for Ian, one for Alison. So does this bring us more into line with the Chapter 11 process in the States? Is that how you see it?
Is that for me or for Alison?
Yeah.
For me,
Ian,
okay.
One for you, Ian.
Well, Alison did touch on it. I mean, certainly it's a debtor in possession process. The big difference here is that you've got me as a lovely monitor involved dealing with it, who can probably act a bit quicker than the courts can in the States. I'd like to think I'm a little bit cheaper than going down a court process as well. So I'd like to think there's more flexibility for us to actually get where we want to get to, and that's for all stakeholders, because we can act sort of a little bit more agile than a court process can, which is, you know, quite often a sledgehammer to crack a nut. Given that monitors are IPs, you know, we're going to be looking at it as sort of fairly careful process, and I think everyone in the process can at least have some sort of comfort in the fact that the IP is dealing with the process and trying to understand everybody's needs and concerns, and normally deals with these things pretty quickly. So that's, you know, what we're trained to do. So I'd like to think it's going to be a more streamlined process than the debtor in possession Chapter 11 in the States.
I would agree with that, and I think the other advantage is that the supplier or the credit insurer, whoever wants to, can ring up Ian and say, well, what's happening with this? What's the position? Whereas you can't ring up a court. So Ian is going to be much more reactive on the ground, day to day, checking what's been paid, because one of his key duties as a monitor is to check the payments are being made. So he's going to be speaking to the directors constantly. What's got to be paid today? Has it been paid? Have you agreed any extension? Having a real feel for the cash flow and also what's happening on the rescue. So I think that's a great thing in terms of being an interface with the creditors that are standing still in a way that the court never can be, because that isn't its role. That isn't what it does. It just approves things rather than actually monitors on a day-to-day basis. So I would say it's better, but then I'm English, so.
Could I also make a comment though? But when you think about it though, if you're ordering stuff in a moratorium and it's 20 days and 20 days, say 40 days, and if you have to supply on credit terms, most of those credit terms are either 30 days or 60 days or whatever. So you're not going to have a massive record of payments being made. So I'm not sure exactly how that will look in terms of your monitoring process for that they're actually adhering to the payments and where that will go. So it's just a thought.
But
we're going to have to be, sorry, go on, Alison.
I was going to say, we can't say it's just going to be 20 days. It's 20 business days to start, plus probably 20 more business days. And when monitoring, Ian's going to be looking at future cash flow. So he's not going to be saying, carry on taking the supply unless he can see that the company being around and still in the rescue process to make the payment. So that's part of the analysis, I think, Ian, isn't it?
Yeah, it is. And actually, as IPs, we are going to have to be responsible officers of the court. We've got to be the ones who are saying, we think there's a good chance of a company rescue. And in order to do that, we've got to be happy that they can pay their future obligations.
And if you aren't happy,
you hands-on.
You have to terminate if you're not happy, don't you, Ian? So I think that's
so
I
if we're
think
not
that's the
getting the right information, if we're not getting the right information, or we don't believe the cash flow is going to be there to pay these supplies, we're going to have to terminate. Now, I don't know in practice because none of us have done them yet, but I would imagine we'd have to manage it pretty quickly, because if we hang about and not terminate, then we're exposing ourselves as insolvency practitioners to possible attack claims against us because we haven't acted reasonably. Now, I hope that's not the case, because if it's too much obligation on us, then we're not going to want to give the advice. But I would like to think that, on the balance of probability, if we think there's a company rescue, we've got to do that at least on the basis of cash flows and seeing that we can pay what we're having to pay.
Okay, I knew it was going to be lively. Probably time for just one or two more questions. We've had a couple in about contracting terms pre-moratorium. Would you expect that businesses would be tightening up their contracts at the front end to make it easier for them to walk away from an ongoing contract, like JCT terms or consignment stock?
I looked at JCT terms yesterday, actually, and it doesn't have moratorium as an insolvency event, so there isn't a right to terminate, but no doubt people will try and amend going forward. So I think people will try to amend to have earlier termination rights, as I touched on, but the fact will be that if they're still supplying at the date of the moratorium, then these provisions will kick in, and there won't be a way to draft around them if you're supplying. So, but I would say that's a good thing, because if the moratorium's kicking in, it's because it's a good business. Moratorium's not going to be available to bad businesses. It's a good business that's got a chance of a rescue, and therefore, someone like Ian isn't going to say it's likely to be rescued if it's a bad business, because he's got to believe the directors can turn it around. Otherwise, he won't take the job. So it isn't for those businesses that have been zombie companies for the last 3 years and should have gone bust ages ago. It's really going to be good, I think, for businesses that were very good before, may need a bit of a restructure, but have been hit by 18 weeks of no cash. Yeah. And therefore, if one fixes that by some sort of financial and operational restructuring to adjust to the way forward for trading, then that should be okay. You've hopefully got a good board of directors that can work with Ian to achieve that. And whilst he's doing that, he's making sure people are being paid in the right way. So it shouldn't necessarily be a bad thing for the supply, because if everybody goes bust, there'll be no one to supply. So this is all about rescuing good companies.
Juliana, have we got time for one more question? This one is probably aimed more at COFAS. And I don't know, Frederick, whether we've done a couple of webcasts on the state support scheme. So I don't know whether there's any additional comments that could be made about that. But given that the C-bill loans and the state guarantee for some of the loans being made by the government are actually enacted when there is an insolvency, and the state guarantee for credit insurance is there to keep businesses going, would you say there's any conflict between those two motives? So on the one hand, the bank only gets its money back when there's an insolvency, and on the other hand, the state guarantee scheme for credit insurance, when it actually gets through the EU regulations, is there and designed to keep businesses going. I don't know, Frederick, whether you see any conflict there, whether you've got any comments you'd like to make about that.
Well, not being a specialist, I would defer to Hans if he's got an answer on that. But it may be an opportunity to answer the question which you said. Maybe you would be in a position to tell us today whether we've made any major progress in the scheme. Unfortunately, there's not been such an announcement, but I am cautiously optimistic that it will not be very, very long before we can move forward. And also more generally, you have to take a step back and remember how credit insurers reacted to the 2008 crisis. These are public figures, and so it's very easy to check. But basically, the credit insurance industry removed about 20% of exposure globally. So we're talking probably around the starting point, which was $2 trillion US dollars or euros, and 400 billion, which were taken out by the credit insurance community. Now, where the states have been very, very good at is to make sure that this did not happen this time. And one of the benefits of the engagement which has taken place between the Association of British Insurers and the government is that there have been absolutely no mass reductions. This was condition number one, and this was what we brought forward to the government when we discussed with them and the Treasury, when we said you should probably put something in place to avoid mass reductions. Now, it doesn't mean that there have not been a number of reductions, and depending on sectors, et cetera, there have been a number of actions, but it's nowhere near the impact that we all had to suffer from in 2008 and 2009. So hopefully there's already a benefit of having had these discussions with the government, and in a matter of days or only a few weeks, things will enable everybody to know exactly where we stand. I don't know, Hans, if you've got a particular view on the other question?
No, not at the moment. No, I think you're right. As a government scheme, it's there to support the British industry, and that is by supporting us. And like Frederic said, we have not been en masse cutting limits. We've been selective, and that has been supported as well by the scheme. We have no intention, vice versa, to suddenly reinstate everybody, but we are still looking at everybody on a case-by-case basis. Some industries out there have had a much larger impact than others. For the same token, some industries have also benefited from the coronavirus. So it needs to be looked at on an individual basis, sector by sector, and that's what we're doing from also asking the questions to all the businesses out there. How have you been impacted by coronavirus? And this is how we can support them, by getting information. So also one of my comments around company house filing, late filing, that does not help for us to support the industry out there, because suddenly a lot of people are hiding their numbers. And these are numbers pre-coronavirus, I hasten to add.
Super, Hans, thank you for that. Frederic, thank you for that. I think we're going to have to close up now, close up the shop. We've got a lot of questions, and we'll capture those and we'll share those responses with you as far as we can. Any ones that we've not answered, we'll put those in the pack for you as well. We'll share the slides as soon as we've got the recording sorted out. And I'd like to thank everybody for joining today. We'll be doing another one in a couple of weeks' time on a more esoteric subject than this one. But thank you, Hans, Ian, Eddie, Alison, Frederic, for joining. Thank you for Dom for driving the engine. And we wish you all a great day, and hope to see you soon. Thank you.